Okay, we finished Unit 1 describing an evolutionary process of the law that began in North America in the 13 colonies. This period led up over a period of 200 years to the Revolutionary War. In 1776, Thomas Jefferson wrote the Declaration of Independence. And the Revolutionary War was a very difficult time for the colonists. It meant a time of privation, and it was a very difficult transition. We said that the colonies had been in existence for 200 years, and after 200 years of colonialism, they fought to shake off the government of King George III. They almost didn't succeed. George Washington, the commander-in-chief, and later our first president, feared that we would not succeed because we didn't have the resources necessary to accomplish it. The reality is, if not for the help of France and Spain, we would not have won. And at the end of this conflict, at the end of the Revolutionary War, we in essence had 13 independent states. If you will, 13 independent countries. They had won the war, but had come at a cost. Much sacrifice. They were 13 little countries, and as such, quite weak. They also knew, looking back at history, that they were much weaker apart than they were together. Reviewing European history in particular, and the years and years and years of conflict there. So we began a process of discussing the concept of uniting, of moving from being the 13 independent states of America to the 13 United States of America. But there were problems. What do we know about the colonies at the time? We know that they were very different. We've talked about how the law in the North had evolved differently from the law of the South, how the northern states, if you will, the northern colonies were largely industrialized, and the southern states largely agricultural. We also know from history that the southern states maintained their agricultural economy through the use of slavery. And the southern states were very, very clear in their minds that the northern states, the northern colonies, did not like this practice of slavery, and they wanted it abolished. So we had some very demanding problems to resolve as they began this negotiation to move from independence to the United States of America. It was a complex negotiation. The center of this negotiation was Independence Hall in Philadelphia. You can visit Independence Hall to this very day and see the environment in which these constitutional negotiations took place. The South was very, very worried that slavery would be such an obstacle in this unification process that they were not going to be able to succeed. Interestingly enough, ultimately, the North said to the South, listen, let's just do this. Sign. And if you find that you don't like this unified process, if you don't like the unification, you can secede. Well, we all know what happened when the southern states attempted to secede. We had a civil war. But anyway, let's remain back at this moment of time, just after the war, and the constitutional deliberations that were occurring in Philadelphia. The document that was the result of this negotiation has stood the test of time for over 225 years. It's a testament to what a group of people working, struggling together with a common goal can achieve. It was a very unusual document for its time. It embodied a new form of governance, a form of governance that came from the people. The American Revolution gave the opportunity for a new form of government to be tested. This was a form of government from the people, by the people, and for the people. In many ways, this was a form of government that had been suggested in part by the Enlightenment philosophers Locke and Hume. It was an interesting time in world history because if you really think about it, the American Revolution was the first of many revolutions that shook off the old regime and brought into existence frequently a new form of democracy. Thomas Jefferson, our drafter of the Declaration of Independence, in actuality was not in Philadelphia during these constitutional deliberations. He was in France, helping the French to write the rights of man. And if you read the rights of man in the French, or its original French, or its English transition, you will see, you will hear Thomas Jefferson's language. So this is a new form of governance, a governance by the people. The preamble to the U.S. Constitution reads as follows: "We, the people of the United States of America, in order to form a more perfect union, establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and secure the blessings of liberty to ourselves and our posterity, do hereby ordain and establish this Constitution for the United States of America." Those first three words, we the people, a revolution in governance, a far cry from the governments of King George III, and the beginning of a new era in the common law tradition. Okay. We have a new national government. They have succeeded in forming the United States of America. We have a constitutional document that serves as the foundation for this new legal tradition. How did they accomplish it? What did they agree? Well, as we examine the historical process leading up to the adoption of the U.S. Constitution, ratified in 1788, we see very clearly that the colonial people wanted to limit the size of their new government. They had worked very, very hard to shake off the large excesses of government of King George III. And they wanted to make sure that they didn't replace one large government with another one. So they agreed amongst themselves to limit the size of this government. And to do so, they decided to list the powers that they were going to give to this new national government. We refer to it as the federal government in our federal system today. So they began a list of the powers that were going to be given to the national government. Even more than that, they listed them and numbered them. And to this day, we refer to them as the enumerated powers. The enumerated powers, the idea, the concept behind the enumerated powers is very simple. If a power in question does not appear on this list, it is not a power that the federal government has. The results of this has produced a number of unusual elements if you stop to think about the reality of life in the United States of America today and compare it to the reality of life in other countries. A power not on the list is not a power that the federal government holds. So certain things have evolved somewhat differently. For example, there is no national driver's license in the United States. Certainly, the horseless carriage didn't exist at the time of the Revolution and the development of this new constitutional law. But in many ways, this power held by the states produced driver's licenses on the state level. So if you are a citizen of the state of Pennsylvania, you have a Pennsylvania driver's license. If you're a citizen of the state of California, you have a California driver's license. But that's not all. The legal profession itself has some unusual characteristics directly connected with this limitation of power. For example, there is no national qualifying exam for the legal profession in the United States. All right? You need to be licensed in each of the states that you hope to practice law. Now, this is logical because we know of the historical evolution leading up to the Revolution and beyond. We said that each of the 13 colonies had their own tribunals, their own court system. And as a result, they have their own legal traditions that evolved over time. So if you're going to practice law in the state of Pennsylvania, you better know Pennsylvania law. All right. This has been our synopsis, our overview of the evolutionary process leading up to the creation of this new country, this new form of government, the United States of America. In our next unit, we will continue our exploration of these elements and engage in more comparative law analysis, taking a look at the civil law tradition in more depth and comparing it to the common law elements.
How does a court depart from a previous decision that might have served as precedent or that might have been binding under stare decisis?
Interesting question. As I've indicated in class and our time together, the concept of precedent and stare decisis, these concepts are flexible concepts. They serve as the starting point for the court's analysis. They must address them. But as I've clearly indicated, it's not that they absolutely must follow them. So they serve as the starting point for the analysis, the starting points that leads up to their decision. And if a court does not like the outcome of a previous case, it may choose to depart from it. Now, under the common law methodology, all judicial opinions of lower courts are subject to the appellate process. So a court is at risk of being overturned at the next higher court. But if a judge really thinks that times have changed, that the situation is sufficiently different that they choose to hold in a different direction, they have the power to do so. The way the court would do it is to make reference to the distinguishing elements of this prior case. We actually call it the process of distinguishing the case. And what we end up saying is, what the court says is that these elements of the case, of this case from the past that may possibly serve as precedents, and in extreme cases stare decisis, are different enough distinguishable enough from today's opinion, from today's case, that it really shouldn't serve as binding precedent. So they will go through this process of distinguishing the case. But you're right. Sometimes the case is largely identical. The same issue presented to the court, same question they've been asked, and substantially similar facts. And the question in that instance is, how do they avoid it? Well, the reality is they may avoid it completely by just choosing not to follow it. But they must explain themselves. And the lower courts are at risk of being overturned by the appellate courts above them. But of course, the Supreme Court of the United States, the highest court in the land, is free to choose to follow or not its own opinions. And frequently we will see over time that the Supreme Court of the United States has reversed itself and pushed the law on this issue in a completely new direction. So thank you for your question.